So they've got a fantastic case that we're going to kind of do as a case analysis today that literally had pretty much every issue you could imagine. The insurance carrier threw every roadblock that they could at them, and ultimately they overcame it in the end and got a great result for some deserving clients.
Absolutely. So Jason and I tried the case together. It was a while back in the summer of 2015. And we represented 3 wonderful clients, Jose, Irene, and Eduardo Cardona. And let's just go into, Khail, you want to show some of the PowerPoint so we can show some of the aspects of the trial that we tried. You know, the case when it came to our office was a 1530. So the max limits under the policy were $30,000. And we'll go into what happened the evening when the Cardonas were injured. We'll go into what happened right after the accident happened, how they came to us, and how we negotiated, and how, more importantly, our clients negotiated at first with the insurance company. But I just want to start with this slide, because this is obviously not the creative part. We took this directly from David Ball, Damages 3. When it ain't broke, don't try to fix it. I like to start every case, believe it or not. This is how I started the opening statement. I read this rule statement, no objection, which was a great way to start the case. So, you know, Jason and I probably spent 2 or 3 hours changing this, getting it right. I think the rule statement, even if you can't use it in opening, clarifies your thinking, gets you focused on how you want to frame the case. So these were the first words out of our mouth in the beginning of the case. We obviously had a drunk driver on the other side. We had a very natural bad guy. I'll get into that, but he was, but let's take a look at the rule statement. A person that chooses, obviously we want to talk about choices, because for those practicing in California, when you have a drunk driver and you have punitives in the case, which is what makes all of this relevant, even in your damages case, even in your admitted liability case, you've got to talk about choices under the Taylor California Supreme Court case that talks about when you can give punitives in a drunk driving case and when you can't. Yeah. So, you know, your run-of-the-mill DUI case, not necessarily punitives, but, and I really still don't even understand, Taylor. I don't know if we can branch out there, but it's like, doesn't every drunk driver know they got to go somewhere anyway?
Well, what's great about it is I think most judges don't understand it either, which makes it good sometimes and bad other times. But what's really useful about the Taylor case, for those of you who don't know and don't read concurring opinions, is there's a concurring opinion in there where the judge is kind of dissenting. And I think, was it Justice Brennan? No. Are you sure?
I can't remember. Well, we deal with this every time, because anytime you have a punitive damages case, in this one as well, I believe, they bring a motion to strike the punitive damages. Right. And so you have to deal with Taylor every time, and a lot of the judges don't understand it. We had a case several years ago where one of the judges, frankly, pointed out something to us during oral argument that turned out to be very, very helpful. And that is the concurring opinion in Taylor. If you look at it, he concurs in the opinion itself, but dissents from some of the rules, claiming that it's overreaching. And what he says is the majority opinion effectively has punitive damages on every drunk driving case. And that's what the concurring judge thought. So we have a rationale as far as what they were trying to say. In every drunk driving case, there should be punitive damages. And that's what the concurring opinion said and what he was dissenting from. So we use that in motions to strike, and it's been very effective. I know Khail's used it many times, and it's
if anybody needs a brief on it, I've got umpteen briefs, and we'll be more than happy to load it into the materials at the end of this. And we even have 128.7s where we aggressively say, which is a motion for sanctions against them by saying that they're unreasonable for even thinking that a DUI case doesn't give somebody punitives. So
those we haven't been as
we haven't won those. We're still working on them.
But they deny the 128.7 and give you the punitive.
Give you the punitive. So it is very, very helpful.
Very important to have something that you can lose and win.
Exactly. Because in this case, we can kind of.
It's going to be a long day, guys. We're not even past the rule statement.
Yeah, they did take an interesting tact with regards to punitives, and it was really focused on that Taylor issue.
Yeah, they outsmarted themselves.
They did. They said, we're going to get out of punitive damages by claiming the guy was so intoxicated that he could not have known what he was doing.
Right.
I guess, to put it bluntly, that didn't work out well for them.
So what we did is at the very beginning of the case, we spent a lot of time framing our rule statement. So choices, because we've got the punitive standard, to drive drunk and causes a crash that hurts people is accountable. Accountability is a big deal. I'm sure all of you that have seen Rex's webinars, he's drilled into us over the years that you never talk about responsibility, you talk about accountability. And that's because there's been a lot of political polling. And I don't know the reason, but I do know that accountability is much more persuasive than responsibility. So that was another word that we spent a lot of time thinking about. And then for all of the harm, that's pretty much David Ball. We're stealing that. Not just some of the harm, all of the harm, because we had a lot of injuries that were disputed, a lot that were admitted that the defense couldn't run from. But so that's how we start the case. Obviously, big property damage, obviously a bad guy, but let's look at a picture of who we were dealing with. Mr. Cortez, in February of 2011, at about 1 o'clock in the afternoon, our defendant, Mr. Cortez, goes to a friend's house and he starts drinking and watching a soccer game on TV. He is away from his home, which is important under the Taylor standard we were just talking about. And he proceeds to get pretty much falling down drunk with his friend at the home. And he stayed there for about 5 hours. And just before 6 o'clock, he gets in his '99 Ford Explorer, gets behind the wheel, and let's go to look at the roadway. So we've got a really, really drunk guy. I can't believe this happened. This is a special interrogatory. Actually, it's a form interrogatory. We just asked him questions about his intoxication level this day. This was the first sign. This is early on in the case. First sign this was going to be a special case.
Is that a lot?
I think it's a lot.
Is it? Oh.
I guess, if it's one of those airplane bottles. If it's an airplane bottle of tequila, we're good. But the jury, I think, just when they saw this, Jason, when we must have said 3/4 of a bottle of tequila. It was so bad so we were trying this case and there was a defense lawyer and there were probably 5 insurance company representatives in the audience. And every time we'd say 3/4 of a bottle, we'd look at all them. And the level of contempt, I hope some of them have joined us today.
We did creatively space out. So throughout the trial that would come up routinely for various reasons. And that was strategically trying to played his video, read some responses and got it in elsewhere throughout. So we were always reminding the jury of this guy drank 3/4 of a bottle of tequila.
Yeah, and when you get it in writing and we get to tell the jury that their lawyers actually sent this document to us, it has a little more heft. So yeah, he's loaded behind the wheel. Let's show the roadway. This is Highway 138 going up and down on the screen, which is a highway in northern LA County, the northeastern edge of LA County, and it continues on into both Kern and then I guess into San Bernardino as well. We have a lot of cases from Highway 138. I think it's known as Blood Alley, right? Yeah. I can't tell you how many cases we've had from 138, but that's a side comment.
Yeah.
Death Highway.
Death Highway, blood, whatever.
Blood Alley.
Yeah. Blood Alley's better.
Yeah, so our clients, the Cardonas, are driving this way on 47th Street East, which intersects with 138. And the Cardonas are in a sedan, and they're driving, minding their own business. And at the same time, we know that the loaded Mr. Cortez is going the other way. We'll look at his view, which is the next slide. You can actually see there the skids where, actually, I don't know if that was him, but that's the trajectory of how his car went. So we just went with it.
It was close enough.
Yeah.
He went across double yellow. And
I think one of the cops testified those were his skid marks.
Yeah.
Without really knowing
that is. He got in there.
I think you let him on
Alex,
that one.
people are having a hard time hearing you. So if you could, I know you want to get closer to Jason anyway.
I do. Yeah. So those are the skid marks that Mr. Cardona caused when he loses control of his Ford Explorer, goes into oncoming traffic at the exact same time our clients are driving the other way on that street. And it was, he was going 50 miles an hour, I think, at the time of impact. So he was really hauling it, and you can see the property damage in the next picture. It's a huge crash. The car is obviously totaled, lots of property damage. And, you know, when the cop gets to the scene, he asks Mr. Cortez where he was, what he was doing, and he has no idea. They even said, this is the kind of testimony that really helps you in a DUI case. But what he said is, I don't know where I was. I don't know where I came from. And they said when they approached him, when they were a couple feet away from him, the smell of tequila was overwhelming. So obviously we spend the first part of the trial focusing on the defendant. You know, start with your bad guy we didn't talk about the Cardonas for the first half an hour, and the witnesses obviously focused on him and the defense medical people, which we'll get into. So this was the crash, and then we'll show terrible transition. Khail's going to give me a hard time.
I mean, I was going to let it go just for this one time.
Usually we use Keynote. We had a backup of this on PowerPoint, but these are our clients. Wonderful, absolutely wonderful family. There's Jose with Eduardo, who was in the back, and his wife, Irene, who was the passenger. And Eduardo was 22 at the time. Jose was 59, and his wife was 52. Irene was 52. So let's go into a little bit of the injuries.
Yeah, I mean, as you can imagine.
We are showing these slides in opening, William. These were all, actually, I don't think we showed the rule slide in opening. I stated that on the record, but the rule slide we did in closing. But the rest of the slides, the judge let them in because they're pictures, you know, there's nothing argumentative about, we're being argumentative right now telling you about the case, but we did it on a factual basis at trial.
Yeah, and with regards, as you can imagine, this case, it was admitted liability. They came in and admitted liability on the case. They couldn't do anything else. So the whole case stemmed around the injuries, and some were clearly conceded, others were fought vigorously.
Oh yeah, let's go to the next slide. We have the summaries of the injuries.
Did you get this in an opening?
We got this in closing.
Okay.
Definitely now. This is just so we can tell everybody what the injuries were, what was disputed, what wasn't, what we were dealing with at the time at the time our clients made the policy limit demand, so you all can understand the dynamics there. So the accident is February of 2011. Those are the dynamics of the drunk driving. Jason, you want to just talk a little bit about the injuries?
Yeah, so the orthopedic injuries is certainly the fibular fracture, the talus being extruded. It came out actually of the skin, as you can see in the picture, and the right tibial plateau fracture, the patella fracture on the left knee. Those things were not disputed. The future care necessary for those was certainly disputed. The shoulder tear was disputed and fought, and the traumatic brain injury, that was heavily disputed.
Why did you get an understanding as to why they would fight something so small in comparison,
like the
as a shoulder?
So here, yeah, he was a welder. So yeah, Jose was a welder, very hardworking guy, 6 days a week, 10 to 12 hours a day, worked in the San Fernando Valley and drove up to Palmdale at night. So away from his family most of the time. And they basically said he's a welder. He had a physical job. I don't know why they fought it, but yeah, I think it was the defense. If it's an injury and I can argue pre-existing, I'm going to do it, yeah. Right? They can't get out of that.
And so like the disc protrusions, that was no real treatment for that, and no future care was for that. So whether or not those were caused for it, that was not litigated by us really, because the experts were not fully supportive with us on that.
That's a nice way of saying
it. But the big injury that was disputed, at least as far as Jose, was the traumatic brain injury. That was the focus of defense, because they knew that was going to be the driver of any verdict.
So we're going to get, Jason's going to get really into the TBI and the trial and the evidence and the experts on that. But I want to pause because at the time of the policy limit demand, which was 2 months after the accident, right? Dan?
I think it was earlier, maybe.
No, it was within 2 weeks.
Yeah. Okay, take that, but we worked fast.
Well, we did.
The client
I'm sorry. Yes, my bad. Well, we can talk about that because we wouldn't have taken a fee if they paid it at that point anyway. So,
well, why don't you guys explain that in detail?
Yeah.
How did the case come in, and then did the client already do their own demand, or did you tell them, hey, we think you should do a demand, we won't take a fee?
Yeah.
How did that all work?
So without divulging your attorney-client information, typically when these cases come in, we know severe injury, low limits, insurance companies usually pay those really quickly. And so we're not, you know, in a $30,000 policy with injuries of this magnitude, we're not going to take a $10,000 fee. So, you know, typically the client will just do their own demand. They'll send the police report in or whatever information they have. And, you know, if the carrier pays it, the case is over, client keeps the money.
And Dan, we don't, this is very important. We don't know the limits when we make that deal with our clients oftentimes.
No.
We have lost millions and millions
Absolutely.
of dollars over the years, saying to a client that's horribly injured, listen, we know the realities, right? What's the make and model of the car? What's the address? But we never know the limits. So it's an educated guess. And we have had times where the client comes in later and says, hey, I did my policy limit demand to the insurance company. Oh, and by the way, there was $1 million in coverage. There was $500,000. There was $250,000. And we do not take a fee in that circumstance. So that's what the Cardonas did. They did I think I actually have a slide of their PLD at some point. So that's what happened. They did their own PLD. Yeah, there we go. I think we could show this, right? Clients wrote a letter to the insurance carrier. We just wanted you all to get an idea of what were the clear injuries at the time that PLD was made, because the head injury was not clear at the time. We had to deal with that at trial that Jason will get into, but we sent the police report. I think the police report had an outline of kind of what we're saying here. The injuries, basically the lower extremity were Jose's major injuries. Irene Cardona had a wrist fracture.
Yes.
And actually, you know, Eddie, the son,
had a laparotomy.
He had an abdominal tear. He had a laparotomy in the hospital, but he was a tier 1 trauma patient. The rest were 2 and 3. So it looked like at the time of the accident that the guy in the back, the son in the back, was the biggest injury, right?
Yes.
Yeah, I mean, as far as emergent is concerned, you know, he was rushed to the hospital. They all were, but
did the police report identify some of the injuries?
Yes.
Okay.
Yeah.
So that's how you kind of would or the clients would get away with not having to send medical records.
Right. I think they had an authorization, right? Do you remember?
I think the insurance company may have reached out to them and actually sent an authorization, and they returned it and said, here you go. Here's the police report. We're really badly injured. Well, we'd like to settle for the policy limits.
Right. So I guess we could go back to the injury board. I think we talked about Jose Cardona's injuries, mainly that foot, you know, the talus bone is central to the knees. And the knees, the meniscus tear and the plateau fracture.
Who did you guys use for these kind of graphic and gnarly illustrations? Do you remember?
Oh,
was it Med Visual?
We should give a shout out to whoever did this. I'll find out, and we can add it. It doesn't say on there, does it? Their logos. Yeah.
Sometimes we cut them out for the trial, but
yeah, I forget, but they deserve mention. You like them?
I think they look, I mean, I'm kind of grossed out just looking at them, which is interesting because they're not real.
Yeah, they did a good job. And what we do with the boards, just for trial, not only do we have a screen up there where we can show this stuff to the jury and have the witnesses go through it if we need be, we also print out big boards so that we can put those in front of the jury and potentially go back in the jury room if allowed. So there's several reasons to do that, just so you can have the witness coming down and touching something different, moving it around, looking at the screen. We want the witness to move a lot so that they have control of the courtroom when they're teaching that jury.
Jason, why don't you get on the witness stand and show me what you're talking about?
Yeah, right. Do it live.
We'll do that later.
Yeah, no, we do that. Yeah, in direct. And I know Rex talks a lot about that. But if you're a lawyer in the courtroom and your witness is just sitting there on the stand, the jury's going to lose it really quickly. So we need to find an excuse every, what do you guys, it's 5 or 10 minutes to get them up. And we even switch places. I've seen, you know, we do directs where we'll be over in the witness, by the witness box, not sitting in the chair. we haven't had a judge let us do that yet, but by the witness box, and then the witness is over standing by the jury. If the court will let you do it.
Although Khail did get in the witness box, the last trial Khail and I did, which was just right before everything shut down.
We were one of the last ones to go out of LA Superior Court on an employment case.
And Khail, in closing, got up in the witness box and turned to the jury and got
I
into,
think it was our client.
yeah, he was our client in that witness box, and it was I wasn't sure how it worked, but it was pretty powerful.
They liked it. I had one juror who started crying right then and there.
Well,
Yes.
you were crying too, right?
Well, I was welling up.
Yeah.
I was trying to hold it back, but it was
that was an interesting trial.
it was definitely an interesting trial.
Yeah.
It was,
We'll get there later. I mean, as you guys can see, we talk like this, and we could do this. We could do this till.
But
the sun goes
let's
down.
go back to where we're at. So at the initial intake, yeah, we had the 2 knee injuries and the orthopedic ankle injury to Jose. Irene Cardona, his wife, had a right wrist fracture, which you saw there, and then Edward, their 22-year-old son, had an injury. Abdominal injury, and that was the extent of the injuries, at least when they were initially sent to PLD and at the hospital and upon leaving the hospital.
So clearly worth more than 30,000,
Yeah.
but clearly not worth 21 million. Some of the injuries showed up later. For example, CRPS, complex regional pain syndrome, which we proved clearly from the verdict and the life care plan award, the economic award to Irene Cardona. We were able to prove this, but it was clearly not something that we had established or was even diagnosed at the time of the PLD.
And CRPS oftentimes, I mean, almost always, does not really start to show up until much later. There's a process that goes through as far as differential diagnosis that doctors will go through. And so you'll see them trying to figure out what's going on with the person, why they're continuing to have pain beyond that normal healing process that would take place with a fracture like this. So it was not really diagnosed until much later on.
Which actually, sort of by nature of the disease itself, it can't be diagnosed until the doctor sees the Budapest criteria.
well, and the lab in the Budapest criteria is it can't be better explained by something else. So that it's really a
Which is where the defense
diagnosis, which is where the defense goes to, and they
Always
always
goes.
try to say, oh, it could just be a nerve injury, or which is fine because a nerve injury is bad too.
So actually, that's a key point. Whenever I get a defense medical examiner and neurologist, fighting CRPS by saying it's neuropathic pain, the question is always, okay, is it debilitating pain that's there all the time and is neurogenic? It's nerve-based. Well, who cares what it is?
Yeah.
Who cares what title you give it?
Bruce has a good saying is, at the end of the day, it doesn't matter if it's chocolate or vanilla ice cream, it's still ice cream. You can call it what you want. At the end of the day, it's a terrible feeling that they're getting that's ruining their life, and it was caused by this collision.
I don't know if I can agree with that. Chocolate and vanilla.
You don't like vanilla. You're a chocolate guy.
But either way, what we're trying to say is when you're taking the experts' depositions or in trial, oftentimes they want to just really run away from complex regional pain syndrome, and then they'll give you, well, but they have chronic pain. It's just not complex regional pain syndrome. So, well, they need the same stuff. And oftentimes they'll give you the same treatment. They just don't want to call it that.
Actually, that's a good point, Jason. When you get a defense lawyer, a defense expert to fight you on the diagnosis of CRPS, but they do give you neuropathic or neurogenic pain. Yeah, what's the difference in the life care plan? What's actually different? Maybe, I mean, you still need a stimulator, right?
Well, and at the end of the day, the treatment for pain is always the same.
Yeah.
I mean, there's differing choices that you can have, but it winds up being the same dollar amount if you're actually going to treat it.
They'll still do a stimulator for something that's not CRPS diagnosed. Just
Find
based
cases
on
all the time.
Absolutely.
Yeah.
So yeah, if the defense gets so focused on the CRPS label, because insurance companies have CRPS in their matrix, and a case goes way up in Colossus or the other algorithms when they see a CRPS diagnosis, they will fight that because it's part of the institutional calculation of the value. But when they fight it, that's the perfect way of pivoting.
Yes.
Legal jujitsu.
Legal jujitsu.
Embrace what they will give you, and it works. It works.
So we have a really good question from Max Adler. And basically, at the time that the policy limit demand was sent out, you didn't know that CRPS was going to develop. You didn't know about the brain injury. You knew about some of the fractures, but more importantly, you didn't know what the limits was. How do you, what's the the thought process that you go through, other than just saying, oh, it looks like it might be a low policy or not, in ultimately deciding we're not going to represent them, they can keep whatever it is.
Here's what we know. We knew these people had significant orthopedic injuries in and of themselves. We knew that this guy was not going to have sufficient policy limits because most people don't. If he had a 250, 500 policy, that wasn't going to be enough for these people.
Yep.
If he had 100, 300, that was not going to be enough for these people.
If there was a commercial limit, maybe.
Yeah,
Right.
but at that time, yeah, maybe then we'd need to evaluate that, determining what they did in response to the policy limit demand. But odds are, you look at it, odds are most people are driving around with 15, 30 policies.
Especially people that get loaded on 3/4 of a bottle.
Exactly.
Unfortunately, you know.
And so you
It was in
know,
1942 that he was drinking.
yeah, you know, best case scenario with this guy for our clients is 100, 300, maybe a 250, 500, but odds are that it's a 15, 30.
Right.
And ultimately, the injuries would have justified, those orthopedic injuries from our perspective would justify payment of a 15, 30, certainly 100, 300. And we just think it makes sense to get it out.
Is there a risk then, I mean, just looking at it from a client's perspective, because I mean, I know we don't always just say, no, here, you go do your own demand.
Right.
When it's always better to have an attorney guiding the process. Is there a risk from the client's perspective in doing it themselves? Because they don't have guidance, because they're...
The risk would be is, you know, if somebody has substantial assets or has assets that can satisfy judgment, the reality is you basically know when someone's driving a car, 1999, you know, whatever it was, Ford Explorer, and they live up in the Antelope Valley, and they're insured by what's called a substandard carrier, which is...
That's a key point.
Yeah.
Who's the carrier?
The carrier is QBE. We know the QB typically writes 1530s. There's a lot of insurance carriers that we know only write 1530s. So you can gauge pretty much whether there's going to be an avenue for recovery. You know, we've had claims that come in where somebody's driving a brand new Mercedes S. You know, those you figure the limits are probably going to be higher, or the defendant has additional assets. So there you may not do recommend the client do a policy limit demand themselves.
Case by case.
It's a case by case.
No surprise there.
They get roundtabled when they come in, and if we think if the injury is severe enough where we think the client can get recovered, you know, no matter what the limits are, then we'll let them do it because it's their money, it's their injury.
Right.
Now that kind of ties into Roberta Faye had a question. She was asking for the letter that the Cardona sent. I don't think we have any problem giving that out. Everybody can just see it anyways. But do you advise the clients before you tell them to go out on their own? Do you think that you can use the same letter every single time in every single scenario?
No.
Why not?
Every case is different. Every situation is different. And so you got to look at what's going on, whether or not the client can handle it, whether or not the client has somebody else that can help them handle it if they cannot do it.
Yeah.
So you have to evaluate all that, determining what you're going to do. You have to look at what information is already available out there for the insurance carrier, what should be provided, and what information you have available. And so those are all things you have to look at to consider. You never want to do a one size fits all because it's always different.
Yeah. Yeah. The key to the policy limit demand is you have to give the insurance company enough information to justify payment of the policy. You have to make sure it resolves all the claims that are out. Multiple claims, and some of them aren't included in the demand. The insurance company may not pay. You have to make sure to make some provision for payment of any medical liens. So they're all different because each situation is different. Each one requires a different approach. And so you can't, it's not a one size fit all.
Yeah, I mean, and this is